I don't know how much statutory private law you have in Hong Kong. Maybe not a lot. We have all these laws which govern contracts, consumer law, employment law, torts, product liability. No, you don't have product liability, I think. And property law, statutes governing relations between landlord and tenant. And the doctrine of indirect effects says that in order to apply fundamental rights to legislation, you have to interpret the legislation so that it is compatible with the fundamental rights. But in my experience, what this requires from courts is, in effect, to create some new rules, that the statute has to be rewritten in order to permit new rights to be recognised in order to protect the fundamental rights of the parties. So in the context of employment law, for example, we have a law of, it's called the law of unfair dismissal, which says that an employer should not dismiss somebody unreasonably. And in the past, the courts have said it's reasonable to dismiss workers if you don't like what they get up to in their private life. But now that's been stopped by a case called Redfern, where Mr. Redfern was a member of an extreme right-wing political party. The employer dismisses him, and the European Court of Human Rights says that's a violation of his rights. He's entitled to be a member of a political party even if the employer doesn't like him. So to Crisp and Apple, which is a case I've chosen just because of its name, Mr. Crisp worked in an Apple shop with selling iPhones. Only he wrote on his social media page a notice saying his iPhone was crap. It was no good at all. And Apple discovered this message on his Facebook page, and he was dismissed. He claimed freedom of expression, freedom of speech, and the court said, yes, you're right, you're entitled to freedom of speech, but Apple are also entitled to stop you saying bad things about the product if you work for them. So Mr. Crisp lost. And there's some other technical cases here which I've just put on. These are the European cases, which I don't have time to go through. I don't think they concern the interpretation of European directives by reference to the Charter of Fundamental Rights. And my argument about these cases is they basically rewrite these laws in order to create new rights for, in the first case, a consumer, purchaser of a home, and in the second case, workers whose business had been sold. So my point about these cases is that what happens is the statute is rewritten, the law is rewritten by reference to fundamental rights. It's not an interpretation, it's a contra legem, as they say in Europe. And finally, my third example concerns a field in Andorra. Now, you probably don't, I've never been to Andorra. It's a tiny little country between Spain and France in the mountains, and there was a dispute about a field. It was concerned a will, who was going to inherit the field. Under the terms of the will, the property was left by the grandmother to a grandchild who was born in lawful wedlock, who was born through marriage. This child, the child who wanted to inherit, though, had not been born in that way, he'd been adopted. And the case became incredibly complicated because in Andorran law there is no concept of adoption. So they had to use Roman law, but we won't go there. The point about this case is that what the European Court of Human Rights did was it said that when we interpret a will, where you leave your property after your death to your children or grandchildren, when we interpret a will, we will seek an interpretation that is consistent with or compatible with human rights. So they will not approve an interpretation of a will that might interfere disproportionately with someone's rights. And in this particular case, they thought that the grandson would be discriminated against just because he was being adopted, and that would be a violation of his human rights. In that case, the will was perhaps ambiguous. It certainly didn't mention adoption because no one had thought of it, because adoption didn't happen in Andorra. But in an English case, Gregg and Pigott, possibly the will was rather clearer, but the High Court judge did exactly the same thing. He decided to interpret the will so that it included the adopted children because that would be compatible with the fundamental rights of the children, even though arguably the will really left the property to somebody else. So my conclusion is that on this second stage of the argument that the theoretical contrast between direct and indirect effect tends to melt away like ice in a cocktail, slowly but steadily. The more you look at it, the less it means anything. And as a result, the idea that indirect effect can avoid disruption to private law is misleading. There will be disruption, but I think it won't be great disruption, and I think it will be beneficial disruption. And many of the examples I've given already are obviously cases I've chosen because I think the disruption was beneficial. In Paceno against Andorra, I think the idea that somehow adopted children could be excluded would be prima facie normally wrong. Possibly you could do it if you were very explicit, but normally I think you should avoid that. There's some other